INN's Advocate. INN's Advocate is a platform for lawyers having less than 5 years of practice to come here and deliver a lecture on the topic of their choice. Today we have with us Advocate Dnyanesh Bhatkhande. He graduated his law from ABA Law College in the year 2020. He graduated his Masters in Law from Kirit P. Mehta School of Law in the year 2021. Advocate Dnyanesh practices in the criminal laws in various courts in Mumbai. Today he is going to speak on Overview of MCOC and its provisions. So without wasting further time, I would request Advocate Dnyanesh to commence with his lecture. Thank you.
Greetings, everyone. First of all, I would like to express my gratitude to the entire team of Hammurabi Tablet, Advocate Rahul Maskar sir, Advocate Nikhil Dixit, and of course, my friend Advocate Kunal Motwani, who introduced me to this concept of enhanced advocate. So when I was asked to choose a topic of discussion, I was being a trial court lawyer. The first topic that came to my mind was criminal trial, but when I went through the videos, I came across videos which have effectively covered the topic of criminal trial. So instead of going to that topic, I gave it a second thought, and I decided to take up a special statute. So now today I am attempting to speak on the Maharashtra Control of Organized Crimes Act 1999. So today I will be dealing with, and I'll be giving an overview of the Maharashtra Control of Organized Crimes Act, and I will be also dealing with some of its very important provisions that assume importance in the relevant era of criminal jurisprudence. Now, firstly, it is very necessary whenever we learn or we study a statute or a special statute, it is very necessary that why it was enacted. So before the year 1999, the criminal jurisprudence system, criminal justice system was not equipped to deal with or to curb the menace of organized crime and the acts committed by the organized crime syndicate. So there was a dire need to enact a law that could effectively tap and that could effectively deter organized crime syndicates or group of criminals who are committing crimes consequentially or continuingly for a period of more than 10 years, so that a curb can be put on them, they can be tabbed and they can be put behind the bars. So therefore, that led to the enactment of the Maharashtra Control of Organized Crimes Ordinance 1999. It was introduced as an ordinance in the state legislature, and then later on it received the assent of the President of India. Now one may ask that this is a state legislation, but why it received the assent of the President of India? Because as per Article 246, it falls under both the state subject and the central subject. So therefore it received the assent of the President of India. Basically, the object of this act is to keep a tab on the organized crime syndicates, to catch them, to catch hold of them, and to put them behind stringent law. This is basically a very stringent law. The provisions are extremely strict as compared to the provisions laid down under the Indian Penal Code. Now, I will be going to the important and relevant sections that are very necessary to understand the provisions, are necessary to understand this special statute. Firstly, I will be dealing with section 2D. So basically section 2 in any statute is the section of definition. So it is very important to understand the definition, because there are three important concepts in this act. First is continuing unlawful activity, organized crime, and organized crime syndicate. Now I will read out the definition of organized crime syndicate, organized crime, and continuing unlawful activity. Section 2D. Section 2D deals with continuing unlawful activity. Continuing unlawful activity means an activity prohibited by law for the time being in force, which is a cognizable offence punishable with imprisonment for 3 years or more, undertaken either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate in respect of which more than one charge sheets have been filed before a competent court within the preceding years of 10 years, and the court has taken cognizance of such offence. So now there are three important aspects. Firstly, the offence has to be a cognizable offence which is punishable for 3 years or more. Secondly, there have to be multiple charge sheets in the last preceding 10 years. And thirdly, the offense has to be committed either singly or jointly. Either any one person from that syndicate can commit the offense in order to further the object of that syndicate, or it can be committed in group. So these are the three important aspects of continuing unlawful activity. Secondly, organized crime. Organized crime means continuing unlawful activity by an individual, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence or threat of violence or intimidation or coercion or other unlawful means, with the objective of gaining pecuniary benefits or gaining undue economic or other advantage for himself or any other person, or promoting insurgency. So now it is very important to note that these crimes are committed with an objective of suppressing or oppressing the other person in order to gain pecuniary benefits. So basically, we can, for instance, we can consider the offense of extortion. So threat is given out to a person that if you don't give money, we will be killed. So and give so and so money to me, or else you will be shot dead. So these are the ways of threatening people and gaining pecuniary benefits. So this is organized crime. Now I am coming to the concept of organized crime syndicate. So now, so basically, section 2D, 2E, and 2F give out a flow. First, it talks about continuing unlawful activity. Secondly, it talks about organized crime. And thirdly, it talks about organized crime syndicate. So now, organized crime syndicate means a group of two or more persons who, acting either singly or collectively as a syndicate or gang, indulge in activities of organized crime. So now, when an organized crime syndicate is considered to be in action, it is not necessarily that the complete syndicate has to be action. Any one person who is committing a crime, but he is doing that to further the object of the syndicate, is considered to be an organized crime, even if the other members are not in action. It is not necessary that the other members are supposed to be in action, but even if that one person is in action, it is considered to be an organized crime. Now I'll be going over to section 3. So now section 3 is a very important section because it lays down the punishment that is given by the court under the offense under MCOC. Now, of course, it is very necessary to note that MCOC is never invoked alone. It is invoked with the provisions of IPC. So whenever a charge sheet is seen of MCOC, it is never invoked in isolation. There are offenses under IPC which are invoked along with MCOC. So now I am coming to the aspects of punishment. Whoever commits an offense of organized crime shall, if such offense has resulted in the death of any person, be punishable with death or imprisonment for life, and shall also be liable to a fine, subject to a fine of rupees 1 lakh. So now it is very important to note that the Indian Penal Code does not lay down fine that is to be imposed. Fine that is to be imposed for a commission of a particular crime, it is left to the court to decide fine. But the MCOC has laid down specific fine for a specific offense. So now, for instance, here it talks about an offense where a death is caused of a particular person is killed. So in that case, the fine is rupees 1 lakh. So for this instance, we can take the crime of section 302, murder. So in that case, if a person is murdered by an organized crime syndicate in furtherance of their object, or to gain pecuniary benefits, or to promote violence, so in that case, fine is rupees 1 lakh. Now, section 3(1) subclause 2. In any other case, be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall also be liable to a fine subject to a minimum fine of rupees 5 lakhs. So now, in that case, we can take the offense of extortion, which is punishable for 5 years, which is punishable for 5 to 7 years. So in that case, the fine is rupees 5 lakhs. Section 3 subclause 2. Whoever conspires or attempts to commit or advocates, abets, or knowingly facilitates the commission of an organized crime or in an act preparatory to organized crime shall be punishable with imprisonment for a term which shall not be less than 5 years, which may extend to imprisonment for life, and shall also be liable to a fine subject to a minimum fine of rupees 5 lakhs. So now, when we talk about abetment, so in case of abetment, we can advert to the provisions of the IPC, where abetment of a thing is defined. So basically, whoever abets the commission of an organized crime. So basically, organized crime is an act of a group. So any member of that organized crime who abets or who helps the other members to commit that organized crime is liable under this section and can be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and is liable to a fine of rupees 5 lakhs. Now, section 3, subclause 3. Whoever harbors or conceals or attempts to harbor or conceal any member of an organized crime syndicate shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall also be liable to a fine subject to a minimum fine of rupees 5 lakhs. We also now, again, we also have specific punishment under the IPC which punishes criminals for harboring, punishes individuals for harboring criminals. So in that case, if an individual who is harboring a member of an organized crime syndicate or concealing him or helping him hide from the investigating agency, then even that person can be roped in or can be arraigned as an accused under the MCOC and can be convicted if charges are proved against him, and he can be convicted for imprisonment which is not less than 5 years but which may extend to imprisonment for life. And here the fine is again rupees 5 lakhs, minimum fine. Any person who is a member of organized crime syndicate shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall also be liable to a fine subject to a minimum fine of rupees 5 lakhs. Whoever holds any property, now as I mentioned earlier that this offence is also committed with the objective of gaining pecuniary benefits. So basically when money is gained, it is obvious that they will buy it or they will invest it in some property. So here in that case, whoever holds any property derived or obtained from commission of an organized crime or which has been acquired through the organized crime syndicate funds shall be punishable with a term which shall not be less than 3 years but which may extend to imprisonment for life, and shall also be liable to fine subject to a minimum fine of rupees 2 lakhs. So now organized crime syndicate commits a crime, they earn money from it, they earn undue economic advantage, and they buy a property or they buy any asset. So in that case, if that asset is not accounted for, and if the investigating agency is able to prove that the asset has been purchased from the proceeds of organized crime, and so in that case, the person can be convicted for section 3(5) of the MCOC Act. Now I'll be going to the section 5. So it is very obvious that this is a special statute. So for trying offences, for conducting trials under the special statute, we require special courts. So now section 5 lays down the establishment of a special court. The state government may, by notification in the official gazette, constitute one or more special courts for such area or areas, or for such a case or class or group of cases as may be justified in the notification. When any question arises to the jurisdiction of any special court, it shall be referred to the state government, whose decision shall be final. So now a special court is established as per section 5 of the MCOC Act. A judge is required to be a session judge or an additional session judge immediately before he is appointed as a special judge under this act. So special judge is a judge who presides in the special court and he tries offences pertaining to the MCOC Act. A person where any additional judge or additional judges are appointed in special court, the judge of the special court may, from time to time by general or special order in writing, provide for the distribution of business of the special court among himself and the additional judge or additional judges, and also for the disposal of urgent business in the event of his absence, with the absence of any additional judges. So now generally there is no one special court, there are multiple special courts. So in case one special judge is not available or is on leave, so in that case his business can be carried out by other courts. So in that case, business means conducting remands, or if accused is produced, for production of accused. Any business other than trial can be carried out by the in-charge special judge. In-charge special judge, who is the judge who carries out the task or the job of the judge who is on leave, and he is in charge of that court. So that he is the in-charge special judge. So this was the concept of section 5, that I dealt with the special act, the concept of special courts. Now I will be dealing with section 9, that is procedure and power of special courts. So when it comes to procedure, we always think about the code of criminal procedure code, but the code of CRPC is applicable to this act, but there are certain procedures which are embedded in this act. this being a special act. So now I'm going to read out section 9. A special court may take cognizance of any offence without the accused being committed to it for trial upon receiving a complaint of facts which constitute such offence or upon a police report of such facts. Where an offence triable by a special court is punishable with imprisonment for a term not exceeding 3 years or with fine, or with both, the special court may, notwithstanding anything contained in subsection 1 of section 260 or section 262 of the code, try the offence in a summary way in accordance with the procedure prescribed in the code and the provisions of section 263 to 265 of the code, shall, as far as may be applied to such trial. Now, generally what happens is when offences under IPC are committed, and then if the offences are session triable, first the remand goes to the magistrate's court. The magistrate court disposes of the remand application, and the accused persons are charge sheet is filed before the magistrate court, and the magistrate court commits the case to the court of sessions. But now, this being a special court, what happens is the remand, after provisions of MCOC are invoked, the remand goes to the special judge, court of special judge. So here in this case there is no case of committing the court matter to the court of special judge. Once any special act, irrespective of MCOC, once special act is invoked, the remand has to go to the special court, and in that case there is no question of committing the cases to the special court. So this is the procedure and power of the special court. Now I'll be going to section 14. So now as far as MCOC, investigation in MCOC is concerned, there are certain important officers who are involved in the investigation of MCOC. Of course, the inspector of police is there, but there are officers such as the ACP, Assistant Commissioner of Police, Deputy Commissioner of Police, Joint Commissioner of Police, and Commissioner of Police. These are 4 to 5 important officers or authorities under the MCOC Act. Now I am coming to the concept of authorization of interception of via electronic or oral communication. So now if one reads this section, one may have a question in his mind that how can this section be included in MCOC? It is totally, it is an affront, clear affront to the Article 14 and 21 of the Constitution of India. So therefore, this brings me to the judgment of State of Maharashtra versus Bharat Shantilal Jain, wherein the Bombay High Court had struck down provisions from section 13 to 16, which also includes section 14, because intercepting a phone call is a clear breach of right to privacy. That was the contention raised by the parties before the Bombay High Court. The Bombay High Court struck down and it considered constitutionally invalid. So this matter was taken to the Supreme Court, which was later on, initially before the Bombay High Court, it was Bharat Shantilal Shah versus the State of Maharashtra, but then it became State of Maharashtra versus Bharat Shantilal Shah, where State of Maharashtra filed an appeal before the Supreme Court. But the Supreme Court came to a conclusion that this is not ultra vires. The reason being that this is an organized crime syndicate, and organized crime syndicate is a serious threat to the society. And of course, any constitutional right that is provided to us in the Constitution of India is subject to due process of law. So it is very important to note that as far as due process of law is concerned, this section is absolutely valid. One, the investigating agency has powers to intercept or to tap phone calls of the members of the organized crime syndicate. It is absolutely valid. So now I will read out the section. Section 14, subclause 1, a police officer not below the rank of superintendent of police supervising the investigation of an organized crime under this act may submit an application in writing to the competent authority. So now competent authority is the authority as per section 13. He may be a secretary to the government. So basically a police officer has to make an application to the secretary stating that calls are to be intercepted, and in that case the police officer has to mention the following details. First is the identity of the investigating officer or law enforcement officer making the application and the head of the department authorizing the application. Secondly, a statement of facts and circumstances relied upon by the applicant to justify his belief that an order should be issued, including details as to the offence of organized crime syndicate, a particular description of the nature and location of the facilities from which or the place where the communication is to be intercepted, a particular description of the type of communication sought to be intercepted, the identity of the person, if known, committing the offence of organized crime whose communications are to be intercepted. So while an application is made, it is very necessary for the investigating officer to lay down the particulars of the offense, the place from where the call is to be intercepted. Because ultimately, the competent authority has to decide if the prayers are reasonable. Because even if section 14 provides powers to the investigating officer, the prayer should not be unreasonable. Even if this is not an affront to the constitutional provisions, it is very necessary to be reasonable in any case. So therefore, an application has to be made and the competent authority passes orders on that application. Now I'll be going to section section 17. Section 17 are rules regarding evidence. So the rule of criminal jurisprudence is that every criminal or I'll not call him a criminal, I'll call him an accused. Every accused is innocent until proven guilty. But under this code, there are special rules of evidence. Since we had special powers given to the special courts, there are also special rules of evidence. So in that case, section 17, clause 1, notwithstanding anything to the contrary contained in the code or the Indian Evidence Act 1871, for the purposes of trial and punishment for offences under this act or connected offences, the court may take into consideration as having probative value the fact that the accused was on any previous occasion bound under section 107 or section 110 of the code. 107 to 110 is where he is to issue bonds for security or for keeping good peace and behavior as per CRPC. Detained under any law relating to preventive detention on any previous occasion was prosecuted in the special court, where it is proved that any person involved in an organized crime or any person on his behalf is or has at any time been in possession of movable or immovable property which he cannot satisfactorily account for, the special court shall, unless contrary is proved, presume that such property or pecuniary resources have been acquired or derived by his illegal activities. Where it is proved that the accused has kidnapped or abducted any person, the special court shall presume that it was for ransom. So now, under the trials which are conducted under the IPC, where Indian Evidence Act is applicable, of course, Indian Evidence Act is applicable over here as well, but generally there is a presumption that the accused is innocent, and there is no place for antecedents to be brought in trial. So basically, if an accused is prosecuted for an offence under section 302, it cannot be said that he was previously convicted under section 307, so therefore he has committed this offence. But in this case, the special court has powers to presume that if he has abducted a person, he has definitely abducted him for ransom. So basically, when I say ransom is pecuniary gains again. So here, the special court has power to presume that yes, there is grave presumption that he has done that offence in his previous. Because in the beginning, I had mentioned about charge sheets being filed in the last 10 years. So basically, those charge sheets are presumed to be true. They are presumed to be of some value before the special court. So therefore, the special court presumes that the person or the member of the organized crime syndicate has committed that act in past, and that act has bearing on the trial before it. Now, I'll be going to section 18. Section 18 is a very important section because it lays down the rules and procedures of recording confession. So when I say confession, one may advert to the provision of section 164 of the CRPC. The difference over here is section 1, it's under section 164 of CRPC. The confession is recorded by the magistrate. But here, the confession is recorded by the Deputy Commissioner of Police. So I had mentioned there are certain authorities such as ACP, DCP, Joint Commissioner of Police, Commissioner of Police. So here the Deputy Commissioner of Police records confession. So now when the investigating officer is investigating the offence and when the accused person decides to confess his offence, he has to mention it to the investigating officer that he wants to confess the offence, and the investigating officer through the ACP. Now here the ACP is the supervisory officer. So he has to make an application to the ACP, and then the ACP will forward an application to the Joint Commissioner of Police. The Joint Commissioner of Police has to appoint a DCP of a different zone, a zone which is different from where the offence is investigated. So it is very important to note here that the confession statement has to be recorded in a place which is away from the place of offence, or which is away from the place where investigating is connected, so that the so that the officers who are conducting investigation cannot reach him. So now I'll read out section 18. Notwithstanding anything in the code or in the Indian Evidence Act 1872, but subject to the provisions of this section, a confession made by a person before a police officer not below the rank of the superintendent of police and recorded by such police officer either in writing or on any mechanical device like cassettes, tapes or soundtracks from which sounds or images can be reproduced shall be admissible in the trial of such person or co-accused, abettor or conspirator, provided that the co-accused, abettor or conspirator is charged and tried in the same case along with the accused. Now this brings me to a very important concept. Now, for example, when a trial is going on and during the pendency of the trial, accused person dies who has given the confession statement. So in that case, the trial gets abated against that person, and so in that case, the confession given by that person who is dead, it cannot be used as evidence against other accused persons. So this is what this proviso clause says. Provided that the co-accused, abettor or conspirator is charged and tried in the same case together with other accused. Now he is dead, his trial is abated. So therefore the evidentiary value of his statement, confession statement, is absolutely zero. The evidence given by the officer who has recorded his confession has to be totally ignored in that case. Now I'll be going to 18 subclause 2. The confession shall be recorded in a free atmosphere in the same language in which the person is examined and narrated by him. 3. The police officer shall, before recording any confession under subsection 1, explain to the person making it that he is not bound to make a confession and that if he does so, it may be used as evidence against him, and such police officer shall not record any such confession unless upon questioning the person making it, he is satisfied that it is being made voluntarily. So of course, it is the crux, it is the essence of confession that it has to be made voluntarily. So there is no force. So the DCP, when the accused person is brought before the DCP, he has to make sure that he has made the confession voluntarily. So what steps he has to take is, firstly, he has to get him medically examined. So what happens is, when he is medically examined and if he is found with some injury marks on his body, the officer recording the confession can presume that he is forced or he is troubled to give this confession. Therefore, the confession is not voluntary. Now I am coming to section 4. So what section 4 says is, once the confession is recorded, the confession, original confession, along with the accused person, has to be sent to the chief metropolitan magistrate or the chief judicial magistrate of the area, and the accused person has to be produced before him, the statement has to be produced before him, and the chief judicial magistrate or the chief metropolitan magistrate will send the same to the special court, and the special court will take cognizance. So this was the aspect of confession. So now this brings me to the aspect of section 19. Section 19 lays down the concept of protection of witnesses. So as far as the provisions of CRPC are concerned, CRPC has laid down a mandate that the names of the accused person are to be given to the advocates of the defense beforehand. The names have to be disclosed. They are basically, at least particulars have to be given. But here, the trial court has powers to truncate the name of the witnesses. What is truncation is? Truncation is hiding the name of the witnesses and also hiding the address, so that the accused persons, the accused of the organized crime syndicate, cannot reach them or cannot tamper them in any way. So that is how they are protected, and special court can pass orders as per section 19 to protect the witnesses. So I'll just read out. Notwithstanding anything contained in the code, the proceedings under this act may be held in camera if the special court so desires. A special court may, on an application made by a witness in any proceeding before it by the public prosecutor in relation to such witness, or on its own motion, take such measures as it deems fit for keeping the identity and address of any witness secret. So as I said, the names are truncated. So the word truncation is that the names are hidden. In particular, and without prejudice to the generality of the provisions of subsection 2, the measures which a special court may take under the subsection may include the holding of the proceedings at a place to be decided by the special court, the avoiding of the mention of the names and addresses of the witnesses in orders of judgments or in any records of the case accessible to public, the issuing of any directions for securing that the identity and addresses of the witness are not disclosed, that it is in the public interest to order that all or any of the proceedings pending before such a court shall not be punished in any shall not be published in any manner. So now, even the of course the investigating agency can also hide the names of the witnesses when charge sheet is given. So when charge sheets are filed in MCOC, the advocates for the defense get the truncated version. So what is the truncated version? The names of the witnesses are hidden, their addresses are hidden. So wherever the names of the witness comes in the statement, his name and his address is hidden, or any sensible particular that may help or that may lead the accused persons to that witness is hidden. So that is truncation. Now I am coming to section 23. So 23 is a very important section, because that is how this section sets the MCOC Act into motion. Notwithstanding anything contained in this code, no information about the commission of an offence of organized crime under this Act shall be recorded by a police officer without the prior approval of the officer not below the rank of the Inspector General of Police. So as I said, that when the investigating officer comes to an irresistible conclusion that the accused persons are a part of organized crime syndicate and there are multiple charge sheets against them, then he can make an application to the Joint Commissioner of Police. Here they have said not below the rank of Deputy Inspector General of Police. I suppose Deputy Inspector General of Police and Joint Commissioner of Police are of the same cadre. So as far as my practical experience is concerned, I have seen that then application is made to the Joint Commissioner of Police, and the Joint Commissioner he records his observations in the order and he accords prior approval. So that is how MCOC is set in motion. And no investigation of an offence under the provisions of the Act shall be carried out by a police officer below the rank of Deputy Superintendent of Police. So now, when the Joint Commissioner of Police passes an order, he says that an officer of the rank of ACP should be appointed as an investigating officer for the investigation of offence under this Act. So initially the investigation is done by the Senior Inspector of Police or Inspector of Police. Then that Senior Inspector or Inspector of Police becomes an assisting officer to ACP. Then the investigation is carried out by ACP. No special court can take cognizance of any offence under this Act without the previous sanction of the police officer not below the rank of Additional Director General of Police. So when I say Additional Director General of Police, here I am talking about the Commissioner of Police. The Commissioner of Police gives sanction as per section 23(2). So before charge sheet is filed, sanction has to be given for filing of charge sheet. So prior approval is for conducting investigation and sanction is for filing of charge sheet. Now I am coming to some of the most important case laws which I want to discuss, or I'll just give out a brief, I'll talk briefly about those cases. Firstly, I spoke about State of Maharashtra versus Bharat Shantilal Shah, which is a very important case which talks about the constitutional validity of the provisions of this Act. Now, I am coming to the case law of Sher Bahadur Akram Khan versus State of Maharashtra. So, every case law that I am going to discuss deals with the important provisions, that is section 2D, 2E and 2F of the Act. That is the definition clause. In Sher Bahadur Akram Khan versus State of Maharashtra, the appellants in that case had filed discharge application before the special court, which was rejected by the special court. They approached the Bombay High Court. The Bombay High Court quashed the charges under MCOC. So now the reason for quashing the charges under MCOC is that the offences that were, so basically Sher Bahadur Akram Khan was a gang. So basically gang, now when I say gang, it becomes, now we get an idea of organized crime syndicate, so we can relate to it. So here the Bombay High Court, it was argued before the Bombay High Court that the offences committed by the gang were not committed for gaining pecuniary advantage. Of course, threat was given. So basically there was a fight over a water tap and an assault, and a fight ensued, and the gang members, they assaulted the other side, the members of the other side. But here it was nowhere seen that it was done with an intention to gain pecuniary benefit. So there was no money was not involved anywhere. So therefore, the Bombay High Court observed that it is very necessary when MCOC is to be invoked, that the offences are supposed to be committed for gaining pecuniary benefit. Also, there was another point which was raised, is that Sher Khan, of course, the Sher Bahadur Akram Khan gang was where they were actually family members. So basically, it was said that it can form an organized crime syndicate, but the Bombay High Court observed that even if they are family members, it doesn't amount to a formation of an organized crime syndicate. So it is nowhere written that organized crime syndicate should be a part of if there's a family, then they can form an organized crime syndicate. So therefore, the Bombay High Court quashed the provisions, quashed the as charges under the MCOC Act, and it directed the matter to be transferred to the Sessions Court to proceed as per the section under IPC. Then now I am going to deal with the provisions of Mahipal Singh versus CBI. So I just forgot to mention that this act is also applicable to the Union Territory of New Delhi. Its applicability was extended in the year 2002. Mahipal Singh versus CBI is a case which deals with, I suppose it deals with the forgery of MPSC. Oh, sorry, it deals with medical admissions. So in that case, what happened is the offence was prior to the enactment of this act of MCOC of 1999. So basically, Mahipal Singh challenged this before the Delhi High Court, and he later on went to the Supreme Court of India, wherein it was observed that this act committed by him was prior to the enactment of MCOC. So therefore, Article 21 of Constitution of India is a safeguard that is provided to us against ex post facto laws, because it was said that MCOC cannot be invoked retroactively or retrospectively. So one cannot be punishment for this crime, which was once an organized crime, before enacting the provisions of MCOC. So similarly, there is another case of Altaf Ismail Sheikh. So in this case, there was the scenario was similar. The acts committed by Altaf Ismail Sheikh were prior to the 1998, prior to the enactment of MCOC. So therefore, the Bombay High Court observed that MCOC is absolutely not applicable to his act, because it was committed prior to the enactment of the Maharashtra Control of Organized Crimes Act. So it is not retrospectively applicable. So now this brings me to the last leg of my talk, that is some of the important cases of MCOC which are a part of the news. The first one is the 7/11 serial bomb blast case, wherein the bomb blasts were set in pressure cookers. The bomb blast happened on different places in Mumbai, such as different railway stations in Mumbai, rather Matunga, Borivali, Mira Road, Daisar, and many other places. So in that case, the special court convicted the accused persons, and I suppose right now the matter is before the Honorable Bombay High Court, wherein the confirmation cases are being argued. And of course, it will not be out of place to mention the name of Chota Rajan, who is implicated he is a very prime accused implicated under the MCOC Act. And there are many, there is a special court in the Sessions Court which specifically deals with the acts committed by Chota Rajan. So, for example, to mention is the J murder case. J was a journalist who was murdered, and Chota Rajan was implicated as an accused, and there were many other accused, and ultimately the trial court convicted them. So that is one very important case. And also the case of Arun Gowdy. So in that case, Arun Gowdy and his associates were arrested and prosecuted for the offence under MCOC because they had extorted a builder for ransom, and they had also meted out violence. So these are a few important cases, and therefore I conclude my talk in this way. Thank you.
Dnyanesh, thank you very much. It was nice hearing, it was like recollecting law classes going on. Section wise section you have explained, and nicely you have said how the big cases are there. It was a nice overview of this particular act.
Thank you, sir.
So a small token from Hammurabi.
Thank you so much.